Good afternoon, and welcome to the first video in my series called North Carolina Civil Procedure for Non-Lawyers. This video is in no way intended to supplement or supplant the recommendations of a qualified licensed attorney at law. This video is basically only designed to provide basic understanding and information that is publicly available to any non-attorney who's seeking to file a civil action or defend themselves in a civil action in a court of law in the state of North Carolina. This video in no way creates an attorney-client relationship between the attorney on this video or the viewers of this video. Again, this video constitutes general legal information that is publicly available through the North Carolina Legal Aid website regarding civil procedure and civil actions for non-attorneys. Hi, my name is Attorney Tim Kohler. I'm with Gunther Law Group in Manteo, North Carolina. I'm a licensed attorney at law in the state of North Carolina, Federal Eastern District Court of North Carolina, as well as the Fourth Circuit United States Court of Appeals. And this video is designed to give you some basic understanding and information regarding North Carolina civil procedure as it pertains to small claims actions. Now, before we get started in this, I want to caution everybody. There is a great deal of desire among many people to file and represent themselves in civil actions. And I want you all to remember one thing. And I want you to sear this message in the back of your mind. But there's an old adage that says, "He who represents himself has a fool for a client." Keep that in mind. To quote one of our local judges very recently, I see a lot of people coming into these courts trying to represent themselves and doing a very poor job of it. I highly recommend you go get yourself an attorney, because I expect you to be able to draft motions, pleadings, and orders in a legally competent fashion. And if you can't do that, you need a lawyer. So I want to let everybody know that my first piece of advice for you is go find yourself an attorney. You should have one. If you don't have one, if you can't afford one, that's where this information may be of some help. But otherwise, you should always seek to find an attorney. And again, this in no way supplants the advice of an attorney, because every case in and of itself is specific and special in some ways. No two cases are ever exactly the same. So without further ado, let's give a brief introduction to the court system in North Carolina. The trial court system in North Carolina is divided into three different divisions: small claims, general district, and superior court division. These are the trial court divisions of the court system in the state of North Carolina. Now, where your case goes depends on several things: the type of claim and the amount in controversy, how much you're trying to get. In a civil action, the principal relief is money damages. The general rule is that where an adequate remedy at law is available, there is no remedy available in equity. What that means is you can't go out and try to get a court to give you a restraining order if you can get money damages for something that's happened. So very rarely are equitable solutions at your disposal. But specifically, we're going to talk about small claims. Now, to get a case into small claims, you have to be a real party in interest, first. Second of all, the court has to have jurisdiction. And there's two ways that they obtain jurisdiction. First, over the subject matter of the case. The subject matter of the case in small claims is typically summary ejectment, which is an eviction, money owed on a contract or some other means, promissory note, or personal injury. So a small personal injury claim. In any case, the amount in controversy in small claims cannot exceed $10,000. Now, that's a recent change. As of, I believe it was August of 2015, the jurisdictional limits in North Carolina for the small claims division increased from 5,000 to 10. Now, the jurisdictional limit for district court, anything between 10 and 25,000 will go to district court. District court also shares concurrent jurisdiction, which means they can actually hear cases under $10,000 in lieu of the small claims division. So small claims is basically there as an avenue for those who can't afford an attorney or who don't have the resources to expend going through a formal court process. Then there's the superior court division. Superior court deals with amounts in controversy over $25,000 or seeking certain equitable reliefs that aren't available in lower courts. We're going to focus on small claims. Now, I will tell you that going forward with small claims, because they have concurrent jurisdiction with district court, is many times, depending on the type of case, the complexity of the issues, and certain other dynamics of the case, many times I will recommend that we do not take our case to small claims, because in many cases the small claims of judgment, if we're successful, will be appealed by the other side and taken into district court no matter what. So to alleviate that step of taking the case and doing it all over again, and basically costing the client more money, a lot of times I'll recommend we go straight to district court. Magistrates in the small claims division are not judges, so they don't have the depth of legal knowledge that a judge does, which is why you are entitled to a de novo or a do-over appeal straight out of district court, or straight out of small claims into district court. Now, if you are the subject of an appeal, or if you are the subject of a judgment in small claims, you have a right to appeal the magistrate's decision within 10 days of the written order. 10 days of the written order. 10 days of the written order. There is no reprieve from that. So make sure, if you are subjected to a judgment or a disfavorable decision in small claims and you want to appeal, you have 10 days from the written order. If the magistrate makes a disfavorable judgment in open court, you may orally notice your appeal and then go directly to the clerk's office and do the written notice, and it must be served on the opposing party within 10 days of the written judgment. 10 days of the written judgment. Make sure you sear that into your mind. 10 days of the written judgment. Now, if the case is subject to the de novo appeal, it will then go to district court, and you will be subject, most likely, to an order for repleading, which means you're going to have to know how to draft a complaint, an answer, discovery, pretrial motions, all of the formal things of court that you were trying to avoid in the first place. So my first caution with taking anything into small claims is to please be aware that if it is appealed, you will need an attorney. Even if you can make it through small claims on your own, you will need an attorney in district court. Now, in the small claims division, to file your own complaint, there are forms that you can find on the North Carolina Judicial Page website, and you'll be able to fill out your own forms. They're very self-explanatory. There's a complaint for money owed, complaint for summary ejectment, and complaint for personal injury. Now, with these complaints, you complete them, you file them, you pay your fees. The other filing that needs to be accomplished is a summons, and this makes what we call process. You do not have process without both the summons and the complaint. If you fail to serve both, some process is ineffective, case gets dismissed. Make sure you have both a summons and a complaint. The clerk will actually issue your summons, and they will send it to the sheriff to be served. Now, you'll have to pay your filing fees, and in North Carolina, currently, as of November of 2015, your filing fees in a small claims division is $96 plus $30 for service. So it's a total of $126. Once those fees are paid, it'll go to the sheriff will serve it. Now, you must know where the defendant resides, physically, not a mailing address. They must have a physical residence. Sheriff will serve the papers, a court date will be noticed, and you'll go before a magistrate and you'll plead your case. Now, if you want to bring witnesses to testify, you'll need to have subpoenas issued. Let me first point out that if you are not a licensed attorney or a clerk of court, you may not sign your own subpoenas. You'll have to prepare them, take them to the clerk will issue them. They will also have to be served by the sheriff or by another acceptable means under Rule 4. We will not get into that in depth. But I want to point out that if you have witnesses that reside out of state under the North Carolina Rules of Civil Procedure and under the law, you cannot issue subpoenas from one state commanding a non-resident to appear within the state of North Carolina. You don't have the authority to do that, and it's an ethical violation for an attorney to do such a thing. So just be wary that if you have out-of-state witnesses, you may ask them to appear, but you can't compel them. All right, so after those subpoenas have been issued, you have witnesses, you have documents you want to present. Just for example, make sure you have your documentary evidence copied in triplicate, because you'll have to provide a copy to the other side, as well to the court, and have one for yourself and your witnesses. Now, one other thing I'd like to add is that in these types of cases, you may be faced with an opponent who does go out and retain an attorney. And I will tell you from experience that more than 90% of the time, 95, 96% of the time, if you're facing off against an attorney on the other side because you're dealing with a magistrate who is not an attorney, you're probably not going to do real well. So you should very seriously consider hiring your own attorney. And then you got a real fair shot of doing well in that case. On the other hand, if they have the resources to go out and hire an attorney, chances are they're going to appeal it if it's disfavorable. So my suggestion is always hire an attorney. If you do not, and you choose not to heed that advice and you choose to represent yourself, once that case ends up in appeal, hire an attorney. particularly, do not try to go through an appeal on your own. You will need an attorney. Once you get your money judgment in small claims, and no appeal is taken, after 10 days you may begin the execution process, which means you can collect against your judgment. Now, if you are the subject of a civil judgment in small claims and it goes beyond 10 days, and you do not seek an appeal as of right, you have very little relief available to you. I have actually fought these cases before, and they are very, very hard won if you're able to win them. It's an uphill battle, and it's discretionary if the judge wants to give you any relief at that point. But 9 times out of 10, they're going to let the judgment stand because you have such a very clear-cut and established appeal procedure to get a completely new trial. So my suggestion is always get an attorney. If you don't, understand that after the judgment is taken, you have 10 days to appeal, whether it's in your favor or against you. So once you have a civil judgment, let's say you are the defendant and a civil judgment is entered against you, that judgment is docketed and it attaches itself to any real property that you own. A writ of execution and a notice of rights can be served, which means that you will be able to exempt certain property that's statutorily exempt. Anything not can be subject to collection, meaning a writ can be issued, sheriff can collect it, and it can be subject to a sheriff's auction to satisfy the judgment. After that, you can be garnished. There's a number of other ways that you can be subject to the judgment. I will also add for the defendants out there, do not try to hide. It doesn't ever work. Even if you leave the jurisdiction, they're going to find you. You're going to collect the judgment. It will be outstanding. There's no way to escape it. Best thing to do, if the judgment is entered against you and you do not appeal it, you fail to appeal and you have no other recourse, pay the judgment or make arrangements with the other side to make payments on the judgment. So, with regards to small claims, let's just recap. You must file a complaint and a summons with the clerk. Both must be served, and after service is perfected, you both have to appear. You must appear. If you fail to appear, the complaint can be dismissed, and you can lose your right at that point to any relief. If a complaint is dismissed with prejudice for failure to prosecute, it's similar to a double jeopardy type of a situation. You cannot go back and refile it and try to do it again. It's subject to what's called estoppel. So unfortunately, you will be out of luck. So make sure when you initiate the process, you understand, number one, the milestones and timeline of things that need to be accomplished. 2, you understand that if you fail to prosecute, you'll lose your claim. 3, you know what forms need to be filed when and how they need to be served. And 4, if judgment is entered against you or if judgment is disfavorable, how to go about appealing and then what the next step in the process is. So this will conclude my segment on basic understanding of small claims. Now remember, your small claims actions are limited: summary ejectment, which are evictions, money owed on contracts and promissory notes, and 3, on minor personal injury cases. Jurisdictional limit is $10,000, and you will need to file that complaint in the jurisdiction or the county where the transactions or occurrences giving rise to the claim occurred, and or where the defendant resides. If you are the plaintiff in an action and you're seeking to file, the defendant lives in another county, the transaction or occurrence occurred in another county, you cannot file in the county where you live. You will not have jurisdiction. Thank you very much for your time. Thank you very much for your attention. I hope this was helpful and informative. You may find me on avvo.com. My name is Timothy P. Kohler. I'm an attorney at law. You may also find us on my firm website at guntherlaw.com. Take care. Have a wonderful day, and I hope this was helpful and informative. And if you want to email me with any questions you may have, apart from specific questions regarding specific cases, I cannot give just unsolicited email legal advice. But if you have any questions concerning, trying to find an attorney or something to that effect, or you need just some general information on, where to find something, I'm more than willing to answer it. So please feel free to reach out to me. I hope again that this was informative and that you gained something from it. And I want to leave you with, he who represents himself has a fool for a client. Thank you and have a great day.